If you work in the United States, chances are you've signed one of these without knowing what it is. I'm talking about arbitration agreements. An arbitration agreement is a contract between you and your employer that says if there's any sort of dispute with regards to your wages, whether you face discrimination, harassment, or retaliation in the workplace, any of these disputes, which would normally be in court, will instead be taken to an arbitrator, usually a single arbitrator. What does that mean functionally for you? That means that the arbitration will be done faster. That often hurts our clients, the employees. The reason for that is, in an employment dispute, most of the documents, most of the evidence is being held by the employer. We need the ability to make a lot of document requests, to subpoena a lot of documents, and to take a lot of depositions. When we're unable to do this, it not only hurts your case, but it could be the difference between winning and losing. Now, even if we do win at arbitration, there's issues because an arbitrator is picked from a panel and the employer has to agree to the arbitrator as well as the employee. So what happens is, where an arbitrator is selected, if he or she were to give out a very big award against an employer, the employer is going to ensure that they're never used again. They know this, and as a result, there's obviously going to be issues of implicit bias against an employee in those cases. However, if you have signed an arbitration agreement, it's not all bad. You may still have a valuable case, and there are things that can be done, but where you're given an option, you should always take the option to opt out.